get this question a lot from my federal employee clients from all over the United States. And they usually get this question once they have gone through part of the EEO investigation process with that EEO investigator. And the way that process works is they get a series of questions, they answer those questions in an affidavit. Management, the RMOs, or the responsible management officials, give affidavits also in response to what the employee has claimed. And what's supposed to happen is the investigator is supposed to ask each RMO a series of questions to get to the nuggets of truth here as to what really happened, or at least the management's version of what really happened. And then the investigator will contact the employee and ask the employee, do you want to submit a rebuttal to what each of these managers has said? And that's when I get a lot of calls in my office, because people are kind of like, do I submit a rebuttal? Do I not submit a rebuttal? Is it better to submit a rebuttal? What do I do? So it's a really good question. I like rebuttals for no other reason than you will get an administrative judge assigned to your case, unless you go to federal court. Even then, you'll get a federal judge who will take a look at this report of investigation or the key parts to it. And the administrative judge gets a first impression of the case from these affidavits. Let's say it's a failure to promote case and the person didn't get the promotion, they gave it to some other person of a different gender, different race, different nationality. The employee believed this was discrimination. Each of these managers could give in their affidavit the justifications for why the other person was promoted and not you. Okay, so the judge is going to look at that. And the judge's first impression of the case without a rebuttal might be, oh, this is another case where the employee didn't get promoted and is complaining about it, has no real evidence. Oh, I've seen this before. And kind of takes a vacation, a mental snooze, if you will, on the case, which administrative judges do. I mean, they have hundreds of cases and they just shorthand so many of them. So it is really important to submit a rebuttal if you have really pertinent information that makes a substantial difference in what was said. Let me first give you an example of something that I would not rebut. The manager says, yeah, so-and-so, we didn't like her work so much on the Toledo project, and the manager lists 5 things on the Toledo project. You know, you want to rebut that and say, well, it actually wasn't the Toledo project. It was renamed the Toledo-Cleveland project. If the underlying facts are all the same, and this is just a change in the name of the project, you do not want to submit that as a rebuttal, because that looks petty. And the way fact finders, particularly judges, look at these things is they're looking for the nuggets of, is this person overall proving she was better qualified, didn't deserve whatever happened to her, or not? Not that the manager was careless or something like that. The other bit of advice that I give to people is what I like to do on these rebuttals is I actually go through the questions and I point out that the way the questions were worded to the RMO, well, the investigator didn't really do his or her job. And I'll shoot some examples of this. This happens all the time. Here's one. Mr. RMO, was management within their right to make a name selection regarding this announcement and pick whomever? And then the guy says, well, yeah, they were. Absolutely. And you get this question at deposition. The plaintiff gets it, the employee gets it. Hey, Mr. Employee, doesn't the manager have a right to assign work in the way that he wants to? Doesn't the manager have the right to name the acting manager when he's gone the way he wants to, and then the person's thinking, yeah, well, I mean, I guess that's kind of way. That's kind of the way it happens at offices. And okay, the answer to that I always tell clients in their prep is yes, they do, within the confines of the law, though. I mean, yes, in theory, managers do have that right to make the decisions they want to, but it has to be in accordance with Title VII. It can't discriminate against anybody. They can't retaliate against anybody. And people miss that. Another situation happens in virtually every single management affidavit. There is the report of the incident to the manager. Plaintiff assesses that you pressured the complainant with an unreasonable deadline to complete an assignment. Okay, that's the complainant's allegation. Okay, and then the EEO investigator will ask the RMO this question every single time. Did the complainant speak with you regarding this incident? And the guy says, answer, no. Oh, okay, let's move on. Next question. Well, first of all, who speaks in offices these days, particularly during COVID? Almost all of the communication is by email. So really the question should have been, did the complainant communicate with you regarding this incident? And the answer in that case probably would have been a yes. But the investigator didn't ask the right question, and therefore the rebuttal is really limited. Now, I have had situations where I have literally made the investigator go back to the RMO and make sure that the right question is asked. Okay, I have a case right now where I have moved for summary judgment. And it's interesting because what this AJ did was, as soon as the AJ got the report of investigation, she issues this sua sponte summary judgment motion, which means, why shouldn't I dismiss this case? Like what's really the claim here? And they're forms. I mean, there's nothing even like it's evident to me when I got this case. She didn't even read any of the facts or anything like that. It's just a form. They just fill in the caption, they fill in the case law, they fill in whatever. A lot of these people, and I talk about this on an earlier podcast, the way these AJs are kind of judged in terms of their own raises is how many cases they complete a year. So they're looking to knock out as many as they can, and particularly if you're pro se and you don't really know the process, you can lose good cases just based on your own lack of knowledge of how to weave your way through the process. But in any event, I had this case. I moved for summary judgment because a manager put down in a performance evaluation that the complaint that the employee had about being sexually harassed felt threatening to him. And this was about another employee. Okay, now I can assure you that did not come about through any of these EEO investigator questions. All right. In fact, I remember that case, and it hasn't been decided yet, which is an amazing thing if you think about it. Like here, the AJ was so convinced the case had no merit, like you had to put in your response within 15 days. And she was ready after 15 days to just say, oh, sorry, you don't have a case, goodbye. Now, since I put in my own motion for summary judgment, now it's been like almost a year and there's still no decision. Like, whoa, what happened over there, Judge? Wasn't this like open and shut? This guy didn't have a case? Like, what? Like, why is this taking so long? But I didn't really mouth off to her. I've done that earlier in my law practice, as many of you know, and it was not a whole real positive experience. But in any event, just politely, we're just waiting for the decision. That's it. And the question going back to what generated the claim and the way it was handled by the EEO investigator was the EEO investigator asks the manager, were you aware of the employee's prior EEO activity and that she had filed an EEO case? And he writes no, even though of course he was aware of it. Why was he able to say no? Because the question should have been, forgetting about EEO activity and filing a complaint, has this woman ever complained to you that another coworker sexually harassed her, yes or no? When I made the guy answer that particular question, we got a much different answer. Another example, and this is another favorite one, and I'll leave you with this. Okay, so so-and-so didn't get the promotion, such and such happened to the complainant. Mr. Second Line Manager, what was your direct involvement in that situation? And the answer always is, I had no direct involvement, which is probably true. It's a literal truth. Problem here is, Mr. Investigator, did you ask the guy what was his indirect involvement? Did he have any involvement? Those are the things that have to be followed up with the investigator. Some of these investigators are just gonna blow you off. They're gonna say, look, I've done my job, I've made my standard fee on this, and I'm just not. I mean, these are people contracted. They're not federal employees generally. They're contracted. They're on these large contracts with whatever agency, and the agency, if you think about it, what motivation does the agency have to have these investigations done really thoroughly? Absolutely none. I mean, they're being sued. Kind of like the problem that you had in the 90s with some of these big six accounting firms. Public accounting, they're supposed to do audits and they're supposed to really find problems. Arthur Andersen was supposed to find real issues at Enron, and they didn't. And Enron's gone and Arthur Andersen's gone. What motivation was Arthur Andersen going to have at that point to say, sorry, we think that when you declare all your income on a 10-year contract in year one, that's really not a generally accepted accounting principle. And then it wasn't until after those experiences where a lot of these regulations were really tightened up. So now that the auditing profession is better than it was, okay? Still not perfect. I mean, you still had the 2008 debacle and all that. But at the end of the day, there really aren't tight regulations for these EEO investigators. We're kind of in that Enron, Arthur Andersen stage here of sloppy investigations, not finding the materials, not getting to the right questions. And then you had a problem here at the end of the AJ picking up the file and looking like, oh yeah, this is another case that doesn't have any merit. Yeah. So that's my advice, my general advice for these rebuttals. Obviously, if you're in a situation